Welcome everyone to the 15th edition of the Junior Faculty Forum workshop series. This is a workshop where we discuss work in progress, either of South Asian law teachers or papers on South Asia, broadly understood. I am Dinesha Samraratne. I teach at the University of Colombo at the Faculty of Law, and together with Swati Jhaveri, Tarunabh Khaitan, and Arvind, we support Animesh Das, Swati Singh Parma, and Tavani Nayanakara, who coordinate our sessions. We meet monthly to discuss drafts with the author and two discussants who speak to the paper. And the objectives are to help authors to further improve their work in progress, but also more broadly to cultivate a community of scholars in South Asia, but also working on South Asia. So to that end, today we have a paper by Santanu Sabhapandit, and the paper is titled "The Public-Private Distinction in Freedom of Information Laws, a Comparative Analysis of India and England." This is a paper that speaks to what has remained a live topic, not just in India and England, but in many jurisdictions in the world, the whole question of the public-private divide. So look forward to discussing your paper, Santanu, and thank you for sharing it up with us for discussion. We have two discussants, Raeesa, Vakil, and Swati Jhaveri. Raeesa is currently an SJD candidate at the Yale Law School and at the final stages of a dissertation which looks at judicial review and regulatory authorities in India. Raeesa, thank you for joining us and welcome. Swati Jhaveri, in addition to supporting the work of JFF, is a DPhil candidate at the University of Oxford and has been a wonderful resource for the JFF among many other fora in which she and I have been working together. So really wonderful to have you as a discussant today as well, Swati. Thank you very much. So we will proceed as follows. We will have Raeesa speaking to Santanu's paper first for about 15 minutes, followed by Swati. And then Santanu, you have an opportunity to respond, but only if you wish to. And then we'll take the discussion forward from there. So Raeesa, over to you. I will manage the time as well and prompt you if needed. Over to you.
Thank you so much. Thank you. So thank you for inviting me to be a part of this. I really enjoyed reading your paper, Santanu. And so while I have some comments, they're all sort of minor constructive things. I don't have major grouses. It really was a pleasure to read. The subject is something that's currently very relevant because people are really thinking about this question in the context of a very tricky example in India, which is the PM CARES Fund. And there's currently a lot of debate on whether it is a public or a private authority. So this is also, in addition to being interesting, it's also a very timely paper. And I think you're going to get a lot of interest in the subject right now, which is unusual for this field of law. We're not generally a publicly attractive topic. So that should be fun. I'll start by making one or two kind of general comments. And then I have one or two slightly more specific comments about particular things in the paper. And then to end, I'm going to tell you 3 or 4 things that I really liked about the paper. And so if and when you do actually revise it, if you take any of these comments on board, then those are things that should not go at all and should be retained. Okay, so the general points to consider is, one is that there's a lot of very well fleshed out granular detail in terms of the comparison between India and England. And while it's very interesting and well paced to read that, I felt that the conclusion ended a little abruptly. I was looking for something slightly, well, not to be superficial, but slightly longer. something slightly more detailed in terms of the payoff of all that wonderful detail and research and analysis that you did. And it felt like it sort of ended a few paragraphs too short. So when you end, you say that there are possibly two viewpoints to be considered, and you briefly mentioned the weaknesses and strength of each of them. I would have liked to see a lot more elaboration on those, and then maybe some indication of where you think the right direction is to go in. Right. And I know that there's some hesitation when you're doing this kind of work to write a purely recommendatory sort of paper. But even in the sense of considering which of these two options is better, or if there is a third way, it would have been nice to see something slightly stronger towards the end. So that's something that you could think about when you're revisiting this paper, because there's a lot of material that's coming up in your analysis. And I feel like that can feed into a much stronger conclusion. The second thing that I kind of noticed is that I saw a little bit of a lack of discussion of a lot of the existing literature on the subjects that you've discussed. And I don't want to suggest that you should cite for the sake of citing. I know that a lot of American journals will insist that if you mention the sky is blue, you need 18 authorities to confirm that the sky is in fact blue. So I'm not suggesting you do something like that. But using the existing literature might in some cases just give you a sort of shortcut and enable you to avoid traversing what is mostly settled ground. I'll just give you one example, and then when I talk about some specifics, we can think of something more. So a key difference between the two information laws in UK and India is the process by which they came about. So the history of the legislative effort, and you've discussed this in some detail, but at least for India, there's a huge amount of material on the legislative history of the RTI because it's unusually the product of a sustained popular movement, right? And that's slightly different from the legislative history of the UK law, which is at least partly influenced by EU regulations on the subject. And I think that just bringing in a little more of that literature, because there's divided opinion on how much that influenced the actual content of the legislation that was ultimately enacted, I think that bringing some of it in might actually strengthen your argument about some of the legislative choices that were made. And I'm thinking specifically about the fact that you talk about how in the FOI, rather than leave it open to judicial interpretation, there is a list of authorities to whom the act applies. Whereas in India, you have a defined category, which is then interpreted by courts in diverse ways. So looking a little bit at the legislative history of how these came about and the literature on that might maybe enable you to dig into that particular point a little more, and then maybe answer the question of which one worked out better. Was it better to have a defined list, or was it better to leave it open and let it be a sort of justiciable question? So I wonder if that might be helpful to you, and it's worth considering, even if you don't end up sending this to an American journal and having them insist that you footnote every second sentence with like 20 sources. So that's something to consider just in a general sense. And the third general point I had is that with any comparative project in public law, you're ultimately going to have to address two questions, right? The first is why compare? And the second is what did you learn? Now, when it comes to the question of why compare, you actually do tackle this quite well. I like that you raised that there are two aspects of this. This one is the similar legal systems and the sort of history of both the countries. The second is the fact that both laws came about at roughly the same time. So it's a good opportunity to look at how they evolved differently. But again, like I said, if you look at the differences in the legislative background, you might be able to add a lot more nuance to that point as well. It's there. I think you can just elaborate a little more, and that will make it, I think, much sort of richer in terms of responding to what's already out there. When it comes to the second question, which is after you've answered why compare, what did you learn? I think, again, by making your conclusion much deeper, you could actually sort of preempt that question and not have people ask you, okay, you compared, but now what? You know, what did it tell you? Because I think the seeds are all there. You just need to put in a few more paras. Like it's in your analysis, it's in the second to last section, and you just need to sort of bring it to the conclusion itself. So these are the kind of general points that I had. And then there were a couple of specific questions that I had, and these are more questions for you rather than comments on the paper. So just things for you to think about. At least one of them is probably going to suggest that it's a whole new paper that you could write after this one. So don't necessarily feel that they have to be in response to what's going on in this paper. So the first general point that I had is that when you talk about the intention of both the legislations in UK and India, in the Indian context, you talk about the fact that there is no sort of detailed purpose clause as such, right? And then you discuss briefly the preamble. But one thing that I didn't see in your paper is that the Right to Information Act and the preamble makes a very specific argument about how it's necessary to a democratic government that you have free access to information. And that's something that the Supreme Court also echoes in its logic when it deals with right to information cases. And it would have been nice to see that reflected in the paper as well. I know that that means that you have to look a lot at like the literature on democracy and public law, and it's possibly an entire can of worms that you didn't want to open. But if you do decide to open that, then I think that discussing that entire part of the preamble is a good way to lead into that conversation. With respect to the English law, you mentioned that there's no equivalent purpose clause. I can't really comment on that. I'm not so familiar with the English context, but at least in the Indian context, this is a fairly strong avenue of research that's open. And if you do want to leave it out, then I think one good way of saying it is that it's not useful in comparative context to leave it out as well. So that's just something for you to consider. The other thing in this context that I thought about is that you said, and I found this really interesting, that there's a failure to link RTI onto a rights framework in the legislation itself in India. And I thought that was really interesting because I think that there's basically three directions you can take that argument in if you want to build it up further. One is to say that the failure to hinge RTI on a rights framework makes it weaker because rights under the Constitution come with certain protections. So if you read RTI as a facet of the right to freedom of expression, then it comes with certain protections that are afforded to the freedom of expression. Now, the fact that the Act doesn't explicitly invoke those rights may make it difficult to secure those protections. It may not also, because the Supreme Court is quite willing to read those protections, and even if the Act specifically doesn't mention that right itself. So I don't know how strong that argument will be, but if you do want to take it down that path, then you have a lot of freedom of expression literature that you can link to transparency as well. The second direction you can take this point on rights is that you can say that leaving out the reference to rights was intentional, because when the Supreme Court mentioned rights, they mentioned 19 specifically. But by not mentioning 19 specifically, you're leaving it open to read RTI not just as a facet of the right to freedom of expression, but other rights as well. So you can read it as an aspect of the right to life, which at least under Indian law gives certain procedural protections under 21, right? And then you can also say that the reading of rights is interrelated. So it's equally possible to argue that leaving out a specific invocation of rights was intentional and is actually beneficial to the legislation and its intended purpose. And the third and final direction that I think you could take this in is saying that not specifying rights at all, whether it's 19 or 21, is actually a good thing, because as you pointed out in a later part of the paper, rights are only enforceable against the government. And if you are thinking about the different kinds of authorities that you're seeking information against and how you increasingly have hybrid bodies that are not purely public or not purely private, which is sort of the meat of your paper, then not framing it within a rights paradigm is actually better in terms of providing access to information. So it's a sort of comment that you left in your paper that I felt leads to a lot more discussion that could be done in the context of public-private divides. But I also feel like this could be a paper in itself. So again, if you didn't want to open that in this paper, I understand entirely. But I thought I'd mention it because it was a really interesting part and it caught my attention pretty much immediately. I have two more kind of specific points to make, and then I'll pass it on to Swati. So you mentioned when you were discussing judicial review that there are basically two kind of broad tests that are generally considered, right? You're talking about substantial control and then financial control. And what I thought was interesting when you talked about that was something that I had mentioned earlier, which is how does having these tests as justiciable tests impact the implementation of these rights frameworks? So if you didn't want to discuss it in terms of legislative intent, then this is the context in which you could talk about how having a list of specified authorities versus a justiciable category of authorities led to different outcomes in terms of the implementation. You've hinted at this, but I feel like it could have been more specific if that's the direction that you wanted to take it in. And then the last sort of specific point I wanted to make was that when you think about the rights that are listed under the acts, you're also thinking about the positive obligations that these acts are casting upon the government. So in the UK context, there were already existing laws that required government authorities to maintain a certain level of record keeping. In India, that was very much not the case. So the introduction of an act like RTI, it begins with placing an obligation upon public authorities to maintain a certain level of documentation, then provides you access to that documentation as a statutory right. So I think that leaving out that entire part of this, the conversation and focusing only on the access to information part will enable you to write a slightly more streamlined paper. But then people are going to ask, well, what about the fact that these acts do more than give you just the right to information, at least in the Indian context? And I don't know how you fit that into your comparative framework, but if that's something you want to address, like maybe even in a footnote or something, just to preempt people complaining that you didn't mention it, then that's something that you could think about. And then just to end, I wanted to tell you a couple of things that I really liked about your paper. So it's always challenging, and I find this both in things that I write and read. It's always challenging to write a paper that has so much detail and kind of specific information and not lose the reader's interest. And I feel like you've done a really great job balancing detail with specific examples of cases in the course of your discussion. So at no point in your paper was I sort of thinking, okay, where is this going? Where is it leading? What is happening now? Why is he talking about this? So I thought that was really good. It holds your attention from the beginning to end. And if the conclusion is just a bit stronger, I think that would be great. The second thing that I really liked about your paper is that you do at one point talk about how the literature on the public-private divide already exists in the context of, say, constitutional litigation. But then you make a very clear argument that the purpose of a statute like the Right to Information Act or the FOIA is distinct. So that public-private kind of jurisprudence does not necessarily lend itself specifically to this context automatically. You can't directly transpose the arguments from there to here, because what something like the Right to Information Act or the FOI is trying to do is quite different from what courts are trying to do when they distinguish between public and private authorities in different contexts. And I think you did that really well, and it's really important to hold on to that, because what's going to happen is that people are going to read public-private in the title and then say, but where is all the literature on judicial review on public-private? And you don't want to bring all that literature in and take away from the very important conversation you're having, which is about very specific statutes that are doing different things. So I really liked how well you kind of cut off that line of criticism right up front and kept the focus entirely on the question of right to information itself. That's something that I really liked, and you should kind of even maybe push that up front and have it right up in the beginning of your paper. So just to preempt people from kind of dragging you back to debates that have been already carried out over and over again. And just to end, like I said, it's a really timely paper. You may not want to get bogged down in current examples, but when you do have your discussion about the multiple tests, if you do want to bring an example in, then PMKS is a great way to do it, because both tests are being argued. They're talking about financial control and substantial control. And it's pretty clear that it's not apparent from a plain reading of the law about how these tests stack up one against each other. So it's also a good time to be looking at comparative context and seeing how they might have handled this specific situation. Again, you may not want to respond to something that's so politically sensitive, and especially something that's currently in the courts, because we don't know how it's going to go out. But if you want a sort of very juicy example to then it's right there. If you want to take it. But yeah, I really enjoyed this paper. Thank you so much.
Thank you, Raeesa. That was excellent. I was making notes myself because it's helpful to understand this discussion also from the perspective of someone who's looking at public law in Sri Lanka. So thanks for that. Swati, over to you now.
Thanks. So thanks, Raeesa, for those comments. I was trying to, there are a lot of places where our comments kind of interweave with each other. So I was trying to do your comments justice by trying to figure out what I can edit from my comments, but I'm not fast enough. So I'm sorry, Santanu, if some of this is repetitive. I will try and dialogue with what Raeesa said, just so you know where I'm connecting with some things that she's already mentioned. So the first thing I want to do is just sort of say, Santanu, how I understand your project and the ambitions of your project, just so you know where I'm coming from with my comments, right? So like Raeesa said, this is such an important topic. And the example Raeesa gives of the PM Cares Fund shows you just what a critically important topic you've picked up on, to just look at the reach of freedom of information laws. And so much of it hinges on this public-private distinction. So what you're wanting to do with your paper is just interrogate this distinction. And it seems the objective is that you don't want this distinction to limit the reach of freedom of information laws. You want it to have the full reach possible without any kind of artificial doctrinal floors and ceilings getting in the way when it comes to definitions of public and private. So I get a sense of where you stand on the public-private distinction, which is you want to extend the reach of it to its maximum potential, rather than want to be careful that freedom of information laws don't kind of head into uncharted territory, which they weren't intended to go into. And the reason I'm trying to tease out your stand and understand where you're coming from is because one of my general comments is that I want to, like Raeesa said, with respect to your conclusion, I just wanted to get more of a flavor of your own reaction to some of the points and content and information that you're discussing. So yeah, so the way I looked at your paper is you're kind of straddling two objectives at the moment in the paper. So one is to just articulate difference with respect to this public-private distinction, and that's your comparative work. And then the second is there seem to be real opportunities which you come right up onto the brink of doing, which is critiquing the various factors that the different jurisdictions are using. And that really comes out near the end in your conclusion. But I think a paper that weaved that in together a little bit more might be something to kind of explore. So at the end of my comments, I'm going to talk a little bit about the structure of your paper that might help take it in that direction if that's the direction you want to go in. But so that's my first general comment is I feel like the paper is two objectives. One is sort of the describing the differences and understanding the genesis of the difference, which is the purpose of the law is different. So hence you have different ways of drawing the line between public-private. And then there's the more critical work of which one is the better approach. And the reason I say that it is straddling two objectives is because by my word count, it's 20,000+ words, right? So at some point, there's some editorial work that will need to go into the paper depending on where you're targeting to publish it. So yeah, the US law journals generally accept papers with a higher word count, but as Raeesa has identified, their referencing system is very different and definitely not what your paper is doing, right? So you're looking at sort of non-US law journals, and for that 20,000 is on the upper limit for a paper. So that's why I'm thinking editorial work that focuses the paper might be quite useful. So that's the first sort of comment, was to have a very clear aim for your paper, and that will be born out of what is your stance on whether there should be broad public-private definitions to capture more organizations, or do you want to try and be more ring-fenced about it? My second comment relates to the comparative angle of your paper. So a small point on that first. In the UK context, you bring up the environmental regulations that come out of the EU. I wonder if that should just be omitted. I say omitted because that has a very specific EU genesis coming out of a very specific EU directive, which is very different to the mainstream freedom of information legislation. I feel the real comparative similarities come from the mainstream freedom of information legislation in the UK and the RTIA. The EU one is kind of different in flavor. And I know you have a lot of discussion on it because the EU one, in a sense, is the only one that has been litigated in the UK. But that on its own shouldn't be the reason to include it, because if you're looking back at purpose of the legislative frameworks to guide your discussion, the EU context is just so esoteric in its behavior that I wonder if it would create a lot of confusion in the comparative conversation. So that's just one small comment. And it connects to, so Raeesa talked about this as well. You've done some work to justify why you're comparing India and the UK. I had a slightly different view on your discussion there. So I wonder why it is so significant that the timing of introduction was the same. Because if you're trying to say the difference between the two regimes is that the purpose of the legislation was different, then timing doesn't really speak to that main differentiating line. So for me, the strongest reason in favor of the India-UK comparison is they seem to have the same common law roots when it comes to deciding on the reach of public law and public law accountability mechanisms. The public-private distinction has just been such an anchor for deciding on when something is going to be held to account by public law and when it isn't going to be held to account by public law. So I agree with Raeesa that it's good to sideline the judicial review public-private conversation, like we just don't need data fin to be mentioned here. But I think it's worth to just acknowledge that it's that tradition that leads to these conversations happening in similar ways in India and the UK. So I think that's like a very simple but strong case for why India and the UK. So that's my second comment. So the first is on the ambition of your paper. The second is on the comparative work. The third is on your thesis about purpose. So again, you say that the reason we have these differentiated systems is the purpose of the legislation. But in a sense, that's kind of an obvious answer, right? Everything always turns on the purpose of legislation, right? So I'm wondering how we can push the thesis further beyond just looking at statutory purpose, and how we can kind of articulate something that is really, really illuminating about the difference. So I want, like Raeesa said, kind of go back to the parliamentary conversations and the parliamentary debates, because I wonder if what you're really looking for is motive rather than purpose when it comes to the legislation. Because I think the environment, like Raeesa said, the RTIA is like the culmination of this huge popular movement that was pressing for it, whereas freedom of information legislation was England being backed into a corner to enact freedom of information legislation, right? So the political will, the political climate, the political culture around the enacting of these two pieces of legislation is where, to me, there's a very interesting conversation that goes beyond the sort of the statutory interpretation based purpose of the legislation. So yeah, I think on the purpose thesis of your paper, there's a lot of interesting things to uncover. And, this is where we get into methodological terrain. Like as a lawyer, are we able to methodologically have the conversation about motive? And I think we can, because if we go back to parliamentary debates, and, with the RTIA, you have a lot of literature you can lean on, like Raeesa was talking about, which explains the genesis of that legislation. So if you just go to that literature, it's well within our methodological capabilities and also can reveal a lot to us. So my third comment relates to statutory purpose, but I think it's more than statutory purpose, it's statutory motive or political motive that will be the true kind of indicator of why there are these differences between the two regimes. So that's my third. My fourth is, this connects to what Raeesa was saying about your conclusion. I want to know more about your views on this. So which one do you prefer? Is one broad? Is one narrow? Too broad, too narrow? I want a little bit more of your qualitative reaction to the material, because I completely agree with Raeesa. You've done such a good job in fleshing out that granular detail, but I think all that data from the cases needs to be reacted to. There needs to be the what if question answered from that material, right? So I really want to sense, and it really comes at the end in the conclusion, but I think when I do my structural comments right at the end of this, I'll give you if you wanted to just shuffle things around as one of the quick fixes to the next iteration of the paper, there's a way of bringing the evaluative stuff up. So it colors how we read your discussion of the cases. And, for example, on page 15, when you're talking about the cases in India on the RTIA and the second category cases that the judges have been interpreting, then you mentioned that in addition, they've come up with this publicness test. Now, to me, that's, going off script, right? That's the courts going off script and going rogue with their interpretations. Again, I'm really curious, is this a good thing? Is it good that they go in this direction? Is it a good test to have? Just a little bit more of a reaction to that, because just looking at the RTI, right? Does it actually, if your objective is for it to have reach beyond public bodies as such, sort of institutionally speaking, to public functionaries, not public institutions, then is the current drafting of the legislation even going to get us there? Because if you look at the current drafting of the legislation, it's very amenable to a completely narrow definition, right? But you've got the courts continually pushing the boundaries. So at one point, I think it's the Krishak Bharti case, the court said, as long as there isn't no control, there is control. That's a huge obiter statement to make. And I was waiting for the comment on that and, where does this take us? So I think, yeah, with your doctrinal discussion, the granularity needs to be complemented with some critique and some discussion. So I think that was my fourth point. Okay, so my fifth point is, who's the target of your thesis? So if we're going to bring out this critical flavor and this critical element to the conversation, who are we criticizing? Because in India, it's going to be the courts, right? Because they're animating the public-private conversation. Whereas in England, and I'm looking at just the Freedom of Information Act, I'm going to put the EU, the environmental information regulations aside for a moment. There are different actors who are going to be responsible as the primary decision makers on public-private. In India, the courts are looking like they're going to be the ones that are pushing the boundaries on public-private. Whereas if you look at the UK context, it's the Secretary of State under Section 5 of the Freedom of Information Act, who's deciding whether to designate a body as a public body or not. And the courts come in a secondary capacity to judicially review any decision that the Secretary of State makes. I think that's a really important distinction to bring out, just to acknowledge that when you're critiquing the legislation, the problem solvers at the other end are different. It's the courts on the one hand and the executive on the other hand. And how is that going to play out? Okay, structure. So this is my penultimate point on the structure of the paper. So I think right at the beginning of the paper, remember I said I was trying to figure out where you stand on the whole topic, and I know where you stand because I know your work from other contexts as well. So I know where you're going to stand. But I think it might be really good to start off the paper with the problem that you're trying to address, which seems to me that the legislation can be fairly narrow if we stick to real just text, But if we want to just look at the reality out there, which is you have public functionaries outside of government, then we need to think about how to do public-private. I think the problem needs to be stated more clearly. And Raeesa had a really good idea. You could just put up the PM Cares Fund as an example right at the beginning of your paper. I think just to give some examples to your audience about the kinds of situations that might not be captured if we go narrow with public-private, gives your audience an idea of what it is you're trying to achieve when you propose a particular definition of public-private. Are you trying to capture private finance initiatives, outsourcing, contracting out, privatization, and then those gray area, seemingly gray area like the PM Cares Fund? So just to set out, that would be a good structural place to start. I also thought that section 4 kind of needs to come up in the paper. So section 4 is where you set out the purpose of the legislation. And I just remind you of my comment on political motive. So I think that kind of needs to come up because that's your thesis. And to say that, look, these are the genesis of the legislation, which might explain why it's X and Y, because then what you're doing is you're weaving your description of the legislation into your purpose thesis. And it's a kind of an easy way of saving space. And also it starts your line of argument in the right direction. So, you know, like if we were having a conversation on your paper and I said, you know, and I asked you a question and I said, so why are there these differences? Your answer wouldn't start with section 2. Your answer would start with section 4, right? So I always think when I'm writing a paper, I almost start with that conversation in my head about how would I develop an answer in an oral conversation, and I kind of map my paper onto that. So I would start with section 4. In a sense. Okay, then just one more thing on the structure was section 2. At the moment, section 2 goes into a lot of background and information about the two regimes. So you talk about who can make the request, the appeal system and all of that. I think you can omit that. If you're looking at saving space, I think you can omit that and just go straight into the public-private definitions in the two pieces of legislation, because that's the issue you're talking about, right? You're not talking about who can appeal and which bodies are involved. You're talking about how is public-private defined. So I think there's a lot of background description that is a very quick word cut that you can do. Okay. Last comment, and then I'm done, is just again connected to the length of your paper. Sorry, I've lost my train of thought. Just give me a moment. Okay, no, Santanu, I'll send that to you separately because it's a very minor comment. Something that I forgot to mention on structure, and then I'll end with that, is, you know, the cases you talk about in India. So you have like the Chandigarh Club, you have the Indian Olympics Association and things. I wonder if it's worth to just set out somewhere that conversation about what is the typography of bodies that have been challenged or that have been kind of used to push the boundaries of the legislation. Just organize it, because I know that the doctrine the courts are developing looks like it's gone very far. But if we look at the actual outcome in the cases and which kinds of bodies have been used to push the doctrine, I think it gives us another image of the health, it gives another health check of the freedom of information regime, just how far has it been pushed. So I would have just been interested to have somewhere just as kind of an overview that while the doctrine looks like it's gone pretty far, actually the number of bodies that have been challenged outside of, say, the ministry of whatever is not that great. Like the Chandigarh Club, I looked at their website. I mean, you know, it's not a win for freedom of information, right? It's like not even a small win. So yeah, so that's what I'd be interested in. So those are my comments. Yeah. None of this denigrates from what is a great paper. It's just ways in which to refine it. Yeah. Thanks.
Excellent. Thank you very much, Swati, for the wide-ranging comments in your very characteristic, what I've now begun to recognize as your very characteristic style. Thank you. So Santanu, if you would like to respond, or if you have any questions for the discussants, you can take this opportunity now, or you can come back to them later.
Thanks, Dinesha. Both Raeesa and Swati, thank you so much. These are such very, very thoughtful feedback, and it gives me a lot to think about. So I have a few comments, and perhaps I'll come back to you later with if I need more clarifications. But from what I have understood from your comments just now, I would like to respond to a few of the comments. So about the conclusion, I absolutely agree with your comment, Raeesa, that it doesn't come across as a full-fledged conclusion that you were perhaps, a reader would perhaps expect. And the reason being that I actually haven't finished, I could not finish the conclusion part when I submitted the paper. I was still working on it. So so no surprise, it's not a complete proper conclusion. I still have to work on it. But thank you so much for your specific comments. And I think I could address at least some of them in my conclusion. I think that would make it very good. About my use of the existing literature, yeah, I have just made a reference to some of the existing literature on the RTIA in a footnote. I haven't really gone into discussing, the background of the act and the motive, as Swati puts it, about what led to the structure of the RTI that it is in now. Reason partly being, one, I was very much focused on bringing out the public-private distinction, right? So I wasn't really sure how much of a discussion about the motive of the act would really help me in bringing out how the public-private distinction is being defined in the act, and how much going back to the motive will really illuminate the way the courts have interpreted those sections in the act. So I wasn't really sure how much justice I can do to that discussion. So I sort of left it out. But I also take your suggestion that maybe I can consider it to be a separate paper altogether, because it would really make sense to address that issue of how why is it that the RTIA is in the present present state, and what I mean, in a comparative doing a comparison with how the act came into existence in the UK, I think that really makes sense, and I could probably think about developing a paper altogether separately. But here my focus was just on the public-private distinction, and honestly, this is something I did during my PhD, and like you have given the example of PM Care, the entity that I had in mind in my PhD was public-private partnerships. My discussion of public-private distinction is actually linked to public-private partnerships, although I haven't made any distinction or any mention of that here, because I wanted it to be a general paper. Again, I think, yeah, that's the reason I haven't really got into the much of a background of the acts in this paper. Other than that, yes, I also take your points about comparing, or rather making my own thoughts clear in the conclusions regarding which type or what structure of an act I would prefer, whether it should list all the entities already or it should leave it for the courts to decide. So I'll sure think about it and try to clear my thoughts on that. And Swati, about your comments, I agree that you probably didn't find my own stand being clarified in the Act, because I was sort of avoiding taking a normative stand and doing any sort of recommendation saying that this is better or, you know, that is better. So, and that sort of reflects my own approach in my PhD, because I didn't want to say that public-private partnerships are good or bad, right? So what I wanted to say, or what I wanted to establish through my analysis, is that when there is a particular purpose assigned to the Act, and the courts are then interpreting those sections from the Act, are courts being loyal to that purpose? So what I wanted to show is that in the Indian context, you have probably noticed from the analysis of the cases that the courts are going way too off limits in terms of how they are interpreting what is a public authority in the Indian context. So that is a critique that I wanted to make about the Indian law, that although the court themselves say that the RTI is just an implementation of the fundamental right, which should lead to an interpretation that a public authority should be something related to the state. And yet, in their interpretation, the courts are going totally off limit. They are not really trying to see whether the public authority is actually related to the state, because they are interpreting those factors in a very, very liberal way. I mean, it's just the no control example that you referred to, Sati. So it's a very, very expansive way that court are interpreting it. So where is the objective of the Act relevant here? Is the court just going on their own way of what they think it is necessary for the RTI? So how loyal are they for the objective of the Act? So that is what I wanted to bring out through my analysis. So rather than saying where I agree with a broader scope of RTI or not, my focus was on bring up that issue. And that is also one reason why I wanted to refer to the environmental impact, the EIA in the UK. Although it deals with the EU law, how it helps the analysis in my paper is that it has a similar background in the sense that in EU also, you are defining the public authorities with reference to the state. So the opinion that were expressed by the Advocate Generals in those two cases that I have mentioned, that brings it very clearly how a court would maintain that linkage of how we are defining public authority and what is a state. That gives me a very strong point to compare Indian cases with those two cases in the EU, which brings, I think, the distinction strongly that Indian courts are much off the. But I mean, they're really not really being thinking about the objective of the Act or what is the Act is trying to achieve. So that's why I wanted to keep the EIA, but yeah, of course, I'll think about it now. If I maybe just focusing on the FOIA would be better. I'd think about it. About the structure, of course, I'll have a think about it, because of course I'm exceeding the word limits by a lot, so I need to cut down on the words, and probably restructuring it will help. That's all from my side at the moment. But thank you so much. Thank you so much for your comments. They're really, really helpful. Thank you.
Thank you, Santanu. We can now also take questions from or comments from everyone else. So please feel free to either raise your virtual hand or place your question or comment in the chat. So while we wait, I was wondering whether I could also make a few comments, Santanu, on your paper, which overlap to some extent, but perhaps not necessarily with what Raeesa and Swati also had to say. So first of all, I want to know your thinking at this stage about your audience and where you would like to publish the paper, because I think a lot of the decisions that you will make in finalizing the paper would depend on that. So my comments are perhaps also for you to think about broadly in terms of what you will do with the different pieces of this piece, which may not necessarily remain in this current paper, because there is a lot in this paper, I think, which can be developed in the next few writing projects that you take on. So the most sort of obvious one for me was when I was reading the paper, I wanted to know your takeaway point. What is it that the author is claiming by analyzing these two regimes together? And it seemed to me that I had to wait almost till the end of your piece to try and have that brought together and presented to me. So as Swati mentioned as well, perhaps if you can flag that upfront and own it and present that as your main platform, that would be very useful, because as you would know, if it's a paper on RTI in India, you will also have many other scholars reading this paper, because particularly the Indian jurisprudence, as you know, travels in many different ways. So that will be very helpful for your global audience. Now, having said that, I also know that writing for a global audience can always be difficult when you're doing comparison as well. But I do think, as Swati said, that you can be more selective in some of the, and leave out certain description and perhaps zoom in a little bit more on what is most important for you. There, I don't know whether this is okay, but I was wondering whether I should push back a little bit on your comparison and perhaps ask, and maybe even the discussants, whether if you took out, if you separated the two jurisdictions, whether you could still make the same point that you're making in the paper. And if you could, I think your paper could stand very well as a paper that looks at India and develops your analysis of the public-private divide and still have a lot to offer, not just for an Indian audience, but for a global audience. But of course, the comparison with England will always remain useful for any jurisdiction in the Commonwealth for very obvious historical reasons. So that was a thought that I had when I was reading the paper. But again, as you know, I come from a very skeptical perspective on comparison. So that could just be my skepticism coming across. But I wanted to share that reaction with you as well. The other main thought I had was whether you want to draw out two themes that are implicit in your paper. One is the whole idea of the RTI institutional regime as performing what is increasingly now being described as a guarantor function. And that, I think Swati also spoke about how you place the institutional landscape in your paper. I don't necessarily say you should be studying that in this particular paper, but that's an aspect to the RTI regime, which I think is useful to flag in some way. The other point, and this is my final point, was on what your analysis of the public-private divide has to offer to anyone reading your paper on the changing nature of the state. You just spoke to the fact that you don't want to take a position on this, and I can understand that. But I think there is, and Raeesa spoke to this as well, I think even if you acknowledge the fact that this analysis, whether we like it or not, has a determinative impact on how we understand what is public and what is not. And the extent to which we recognize the rapidly evolving nature of the state in terms of all the different aspects, as Swati pointed out, whether it's contracting out or privatization. And this is something that I'm not sort of intuitively placed to do, but I feel like it's also useful to do. Also talk about not bringing certain aspects into the public realm and leaving it in the private, whether there is any value in that at all. Which, I mean, as public lawyers, we sort of have a certain assumption about wanting everything to be subject to scrutiny and being made available. I have that assumption, but I'm also mindful that perhaps it's important to then appreciate the counter argument a little bit and be sensitive to that in how we analyze this. So these are some reactions I had when I was reading the paper, which, I mean, as you can obviously see, I enjoyed very much. Thanks, Santanu.
Thank you, Dinesha. Can I respond to
of course
some of the points? Yeah, in terms of my audience, I think, yeah, I would probably target journals, non-American, like in the probably in the UK or India, you know, in those journals, which would mean that, you know, my footnoting and my word limits, that's all needs to go through some good amount of editing. So that brings to the point how I can perhaps limit, you know, my focus on to a few things and probably leave out some of them. So I think Swati's suggestion that I can probably leave out those details about who makes that decision, who can apply, and so on and so forth. I think that will help me. Yeah, I totally agree with your other comments. But again, it's something I'll probably need to do in a separate paper regarding the institutional issues about you know, who makes the ultimate decision to define public authority. I think the sense I get from your as well as Swati and Raeesa's comments are that, yeah, I really need to make my position a bit more clearer. Even if I'm not making any normative stand, at least I could make some comments about what are my thoughts about the advantages of a particular structure compared to the other. So I think I can safely make that much of a comment. Yeah, and there I think focus on, but this is just my comment for your consideration. I think when we focus on the functionality, that gives us more flexibility in terms of how we define a public function, right? Or public authority, rather than say fundamental right, who sort of fixes us with the state, and then how do we define state, and that's this whole discussion starts. That's why I'm more aligned to the thinking in the UK that when in terms of judicial review, they are very much focused on functional analysis rather than institutional. So yeah, that's my preference. But yeah, I need to bring it a bit more clearly. Yes.
Yeah. I'm in agreement with you. Even I think focusing on functionality is important, particularly at this stage. Swati, you want to come in?
Yeah. You know, this is more of a practical point, Santanu. Like sometimes when I present a paper and then get lots of feedback, it can be a little bit difficult to figure out where to go next with the paper before I can actually submit it and get it into the review process and be kind of done with it as well, right? So first, like which journals to think about, you know, just some journal names to just throw out there, and they will already be on your radar. It's obviously the Indian Law Review. Then there's the Asian Journal of Comparative Law. Then there's the Australian Journal of Asian Law, right? So those are three journals which I think your paper is already stylistically inclining towards in terms of its style and referencing approach and the depth of referencing and the breadth of referencing. So you've already got like a stylistically, you're leaning towards forums like that, right? So if I had to like you can have ambition level A, B, and C for the next draft of your paper, right? If you're looking at just what is something I can do in the next couple of weeks and get the paper out, then if it was me, I would be looking at a paper that was focused on India and would be simply answering the question which you just said in response to our feedback: are courts loyal to the purpose of the legislation, right? And all you do is kind of go have a section which talks about like what the problem is the RTI hinges on public-private. What does public mean? What does private mean? How are we going to figure that out? Does it apply to PPP, outsourcing, et cetera, That's one section, introduction. The next section would be like and then within your introduction, it would be, in order to decide what it means, we obviously have to look back to the purpose of the legislation. Next section, what is the purpose of the legislation? And that's where things like the political motive become relevant as well, because when the courts are interpreting legislation, they don't just look at preamble, right? They do go to parliamentary debate. So you also have to go to the parliamentary debates to answer that. That's your next section. Third, having found my measuring tool, my ruler, which is purpose, section 3, this is what the courts are doing. And embedded in that is, this is good about what the courts are doing, this is bad about what the courts are doing. Section 4, how can the jurisprudence evolve? And all of those sections can already be populated based on what you already have in your paper, right? It's a single jurisdictional study of India, pure doctrinal work, tying it back to the purpose of the legislation, which requires a little bit of digging. That's the only bit which you have to kind of do further research on. And I think that paper, if done, well, is already ready for submission. So that's ambition level A, right? All of our other comments probably speak to ambition level B and C, which you may want to explore in other papers. So I just wanted to come out there and say that, because I have a lot of sympathy for people after a forum, having received so much feedback, like, what do I do next, right? So I think for me, if it was me, I would be going with ambition level A and just extracting that content from my paper and sending it off. That's just me, right? And then B and C are for further projects, because if I try and do B and C now, I'm not even going to get A out. And then there's that demoralization that happens to all academics when you've been with a paper for way too long, and then you get the itch with the paper, and then it becomes frustrating. So that's just a suggestion.
Thanks, Swati. That was fantastic. A good reminder for all of us as well. Thank you. Raeesa?
I agree completely with what Swati said. And based on what you said right now, when you talk about wanting to critique what the Supreme Court and Indian High Courts have done just in terms of judicial review and the RTI, I'm very sympathetic to that line of argument, because I think there's a lot of meat in there. And you do have a scope to write a very interesting paper, because there is a sort of academic consensus that, as Dinesha said, that more transparency is a good thing. And that's very closely tied to the fact that the Act starts off by saying that democracy requires access to information, and therefore we are providing this Act. And then you'll see that kind of line of argument echoed in the court when it completely releases itself from the ties of precedent and law and statute and says, but democracy requires it, and therefore we don't really care about what's public and what's private. You must give the information. And so that's also a very kind of strong path for you to link what you were talking about in terms of the purpose of the Act and why the courts sort of bypass the public-private argument and then just use judicial review to do something completely different. So I think that would be a really strong paper, and I would love to read that. I mean, it would be a different paper from the one you're currently writing. I think both are fine, but it would be very interesting as well. And I know you came here with one paper and it's going to feel like you're going to leave with 3. but that's not necessarily a bad thing. It's a good thing. The other thing I wanted to say was that you mentioned one case, and I think that if you spend a little more time on it in this slide, it will be useful to you. So in 2019, around the same time that the Babi Masjid judgment came out, there was also, I think, a 5-judge bench opinion which held that the RTI Act applies to the Registrar General of the Supreme Court. So it was really, you cited it once in your papers, Subhash Chandra Agarwal. And so it's really a case of the Supreme Court essentially deciding a case against its own institutional structure, which was very unusual. And I think because of the timing, it didn't catch a lot of public attention. No one really paid much sort of time on the logic they were applying to get to that particular ending, because it's very different from their holding in other cases. So notably, for instance, say in sexual harassment laws, they're entirely too willing to say those don't apply because institutionally we're unique, but they weren't willing to do it in terms of RTI. And so it might be interesting to take that as a paradigm if you don't want to use PMKS, which is contemporary, and then say what was different here and sort of think through it in that example. So I know you're familiar with the case, but again, no one's written on this in much detail, at least not in terms of the actual meat of the case. So again, you'd be touching something that's sort of been left out of the literature and really building on it. So I think that might be another way to tackle this line of argument, if you wanted.
Thank you, Raeesa. So I don't have any other questions or comments in the queue, and I'm mindful that we are quarter past the 1 hour. So unless any of you have any final comments, I'm happy to wrap up this session. Okay, Santanu, thank you very much for sharing your work with us. Would you like to say something? Sorry.
No, nothing else, but I just wanted to thank you all for organizing this, and especially Swati and Raeesa for their very helpful comments, and for all the organizers of JFF. Thank you so much. Thanks a lot.
It's our pleasure. Thank you for giving us the opportunity to engage with your work. It was very instructive and also refreshing, and all the best, Santanu, as you proceed to finalize your paper. And remember Swati's reminder not to sort of feel too overwhelmed by it. And I'm sure we can see your article, whichever ambition you choose for yourself, that we will see your article in print soon. So looking forward to that. I just also want to announce our next session, which will be on the 18th of November. It will be a panel discussion that Tarun will convene, where we will be talking about how to write a paper and prepare it for presenting it at a workshop and then revising it thereafter. So it will be more of a hands-on session, which is out of our ordinary approach, which is to workshop work in progress. So thank you very much to everyone for spending this evening with us. And I look forward to seeing some of you at our next session. I just want to thank Raeesa on behalf of JFF. Raeesa, thank you so much for your time and consideration and being with us today. I hope we can see you again at one of our future workshops. Swati, thank you for your generosity again with your time and energy and your thoughtfulness. It was really good to have you as a discussant. And also my thank you to Animesh, Swati Pama and Tavini for getting all the logistics done in an extremely professional way as usual. Everyone, thank you very much and have a good evening. Bye.
Thank you.
Thank you. Good evening.